Hi, everyone. Welcome back. We're coming to you live from Atlanta, Georgia at the 2024 Global Ethics Summit. I'm your host, Bill Coffin, and this is the Ethicast. Hi, everybody. Welcome back to day 2 of the 2024 Global Ethics Summit. I'm Bill Coffin, and with me today is Furdek from Husch Blackwell. Rebecca, thanks for joining the show.
Well, thanks so much for having me, Bill.
So there are some amazing things happening at the DOJ, and they dovetail very nicely with some of the content that's been going on here at the event, especially regarding speak-up culture and whistleblowing programs. So, Rebecca, with that in mind, I want to hit you with our first question. The DOJ has recently announced several enforcement policy initiatives that really impact compliance, including a new whistleblower pilot program. So can you talk to us about that program?
Mm-hmm. Sure, certainly. So on March 7th, Deputy Attorney General Lisa Monaco was speaking at an American Bar Association conference, and she announced that DOJ was going to undergo what she called a 90-day sprint in developing and implementing a whistleblower pilot program. And, what does this mean exactly? She wanted to provide whistleblowers a significant monetary award in exchange for providing information on corporate or financial misconduct. And in doing so, she used some colorful analogies. She characterized this whole idea as nothing new, going back to the days of the wanted posters in the Old West. Law enforcement has long offered rewards to coax tipsters out of the woodwork, if you want to say that 5 times fast. And then she also acknowledged that there are already some whistleblower programs, as many folks listening would know. For instance, there are the key TAM provisions already through DOJ and the False Claims Act, as well as SEC, CFTC with Dodd-Frank. But she characterized these as sort of a patchwork quilt that doesn't cover the whole bed. So there were a lot of analogies flowing on that day. So she provided this new program as perhaps filling in some gaps in that quilt. And while there's a lot of questions, she did provide some basic guardrails of the program. So number one, for a whistleblower to be eligible, all the victims first have to be compensated. Okay. This will take some time in any sort of big federal criminal case. Also, the whistleblower has to be someone who submits truthful information not already known to the government. So it can't be something already revealed in an article or by someone else.
Right.
So that kind of goes back to DOJ's emphasis on being the first to report, to timely, voluntarily report something.
Yeah.
So that's nothing new. In addition, the whistleblower must be someone who's not involved in the criminal activity, him or herself. And finally, there must not already be an existing financial disclosure incentive. So the key TAM provisions are one of those SEC type programs. And finally, again, there's a lot to be learned yet in this sprint, but she did say that they're especially interested in information about criminal abuses of the U.S. financial system, about foreign corruption cases outside the SEC jurisdiction. So FCPA violations by non-issuers or violations of the recently enacted Foreign Extortion Prevention Act, or finally, domestic corruption cases, especially involving illegal corporate payments to government officials. So a lot to unpack there, but we're about halfway through this sprint, so we'll see what comes in the next 45 days.
Outstanding. Well, it sounds like the DOJ has signaled some initial details about the guardrails and the information they're especially interested in receiving. There are undoubtedly still some open questions. So what are some questions that you, or more importantly, your clients, have so far, and where do you hope that the DOJ may provide some further clarity on all of this?
So a lot of people are wondering, I'm curious too, the money. What is the money going to look like?
Yeah.
So if I'm a whistleblower, do I get some percentage of the ultimate recovery? Is there a threshold amount? So for instance, one of the SEC programs, there has to be $1 million at a minimum of sanctions for there to even be a whistleblower award at all.
Sure.
So is this only for the largest of cases? And again, does the percentage vary by the type of statute or offense at issue? We don't know any of that. Another question a lot of people have had is everyone eligible? So for instance, a compliance officer where there may not be legal privilege, like with in-house counsel, and they learn information, can they report that?
Yeah. Okay.
You know, it's a serious question. And it's kind of an interesting one. From the perspective of someone who deals with a lot of different government agencies, there's also the question of what's a sort of overlap will there be, so for instance, if somebody reports something to DOJ, that's usually in the purview of SEC, but there's really not an SEC whistleblower program. Will both agencies be involved? Will it only be DOJ? A lot of questions like that.
Yeah. Do you mind if I ask you a follow-up question on that?
Yeah.
So historically, when the DOJ, rolls out a program, and there are some unanswered questions, do they tend to sort of, address them as they come up in a practical sense? Like, when you see those points of those hypotheticals become realities, is that when they tend to adjust and adapt, or do they try to get ahead of that and deal with them more proactively?
I've seen both. So for instance, there will sometimes be sort of follow-up policy statements issued, whether at these sort of conferences or online. Also, I believe already 2 U.S. attorneys' offices, one in New York, one in California, have already rolled out some policies kind of relating to whistleblowers. So some jurisdictions are looking at that as a guide of what's to come.
Sure.
And ultimately, when they bring these cases, DOJ will use some of these initial settlements or, large cases with a lot of notoriety to sort of set the tone or provide an example of what's to come.
Yeah.
So it's a little bit of both. A little bit of initial table setting and a little bit of just enforcement serving as an example.
So outside of that, what are some practical consequences you see coming out of this program?
Well, number one, obviously there's now an incentive for individuals to report some of this misconduct that might not have been in a pre-existing whistleblower. And number two, I think it'll drive companies to think about the value of their own internal reporting system. Now that there's this new incentive in place, what incentive can I as a company now have for people to report to me? So emphasizing that you might get results quicker by coming to me first, something like that. Companies should also think about just what do their policies and procedures look like, because now potentially if there are more whistleblowers coming forward, that just means more touch points with the government when the government comes to you, wanting to learn what's going on.
Yeah.
And finally, as somebody who, has some work in trial courts a little bit, as all of these actions will go through the criminal process, whistleblowers may not remain anonymous as they sometimes do in other contexts. Okay. It would be surprising if the whistleblower didn't end up being a material witness in one of these proceedings.
Yeah.
So, that's something for someone to think about as they're coming forward, if they're willing to potentially be out there publicly.
Interesting. Okay. So do you have any other advice to share for companies, particularly as to their compliance programs, as they consider this new pilot program?
Well, as mentioned earlier, now that more people might be coming forward, it's kind of time to step back and think from the perspective of their employees. Why would the employee want to report internally? So again, time may be one reason why. Individuals feeling just invested in their culture and like they have a really good culture and have good modeling, tone from the top, that sort of thing.
Yeah.
Again, emphasizing that things can get resolved quickly and that there's visible consequences of what's going on. So if there's non-compliant behavior, how does a company address that? Do they address it? Do employees see the consequences of what happens?
Yeah.
And the same goes for good behavior. If a company does something really well and models it in a compliant way, do employees learn about that? Is that rewarded kind of publicly in front of everyone?
Yeah.
And then finally, again, are your written procedures and policies up to date, especially with all this evolving guidance? Because now if the government comes knocking as a result of one of these employees' allegations, it's important to kind of have everything ready to show them.
Indeed.
So there's a lot, and it's again, we're halfway through the sprint. We'll see what the next 45 days bring, but companies should start thinking about this and how this might evolve over time.
Indeed. Well, I sure appreciate you coming on the show and sort of explaining these things. It's always a when Lisa Monaco speaks, the world listens, and she always brings some pretty material things to bear. So thank you very much for offering us some guidance on this. Sure appreciate it. Thank you for joining us on the Ethicast. And if you enjoyed this episode, I would encourage everybody out there, at the risk of embarrassing you, by all means, Rebecca has also co-authored several articles that have appeared recently in Ethisphere magazine as well. So please make sure to visit magazine.ethisphere.com to see what she and her colleagues have been putting forth to advance the ethics economy. So with that, Rebecca, thank you so much for joining us. It's been a pleasure to have you.
Pleasure to be here.
Indeed. We're coming to you live from the 2024 Global Ethics Summit in Atlanta, Georgia. We're wrapping up day 2. Day 3 is not far away, so be sure to stick around. And until then, remember, strong ethics is good business. We'll see you soon.